Hi, a very good morning. Welcome to our first panel discussion on patient-based value in clinical decision-making. I'm Yen Jing, palliative care physician from Selayang Hospital. I'll be your moderator for this session. I am delighted to invite Dr. Richard Lim on stage again to bring us through the various important considerations in making patient value-centered decisions, followed by Dr. Fadhlina, giving us insights specifically into the religious and legal considerations. Dr. Fadhlina is a doctor of philosophy and law and currently lecturing in E-Symp. Passion is in end-of-life care and had recently published a very important article on the need for regulatory reform for end-of-life care in Malaysia. We will approximately have 10 minutes for Q&A after the talks, and you are encouraged to pose questions on our live chat box. I will now pass the stage to Dr. Richard and Dr. Fadhlina.
A very good morning again, ladies and gentlemen. And now, so to start off this panel discussion on patient-based values in clinical decision-making, what I'd like to do is to just briefly raise a few points on this issue and talk about how it relates, or patient values relates in the context of the COVID-19 pandemic. So I'd like to begin, though, with talking a little bit about ethical principles in clinical decision-making in general. And of course, the first principle I'd like to talk about is the sanctity of life doctrine, which states that all human life has worth and actions that end life directly or indirectly are wrong. And this is in keeping with our traditional code of medical ethics that doctors should save and preserve life. Now, another very primary principle in clinical decision-making for doctors is the well-known primum non nocere, or first do no harm, whereby in clinical decisions, we must always consider not to cause any detriment to our patient. Now, the next is the 4 bioethical principles by Beecham and Childress, which I'm sure many of you are familiar with, which talks about the principle of autonomy, which is to respect the individual and their ability to make their own decisions and choices. The principle of beneficence, where the actions that we do are intended to benefit the patients or others. Non-maleficence, where the actions or choices or the clinical decisions that we make aim to try to reduce and prevent harm or intended harm to the patient. And finally, the principle of justice, which is being fair or just to the wider community in terms of the consequences of an action. Now, if we have a clinical decision that we need to make and we want to consider, the ethical principles, we can do this by applying a method called the 4-box method of decision-making by Johnson, Siegler, and Winslet, where we can apply these principles looking at 4 key clinical areas. First, of the medical indications of the scenario, considering the principles of beneficence and non-maleficence. The patient's preference, which considers the principle of autonomy. The quality of life for the patient, considering the principles of beneficence, non-maleficence, and autonomy. And finally, the contextual features of the scenario, which refers to actually the unique circumstances of each individual case, where we then consider the principles of justice and how these unique characteristics influence the balance of that principle of justice. And so in any clinical decision, as I said, you can apply the 4 bioethical principles to these 4 clinical areas to give us a better overview of the situation that we're facing so that we can weigh up and make decisions better. Now, having talked about the ethical principles, now I'd like to then talk a little bit about patient values and what factors we should consider when taking into account a patient's values. And to do this, I'd like to then highlight a few articles from the Universal Declaration of Human Rights that highlights these very important values, which are the rights of a patient. And the first, of course, is from Article 3, stating that everyone has the right to life, which is in keeping with that first principle of sanctity of life. Now, the second is in Article 5, which states that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment. And so this is an important right and in the patient's value of quality of life. Article 13 specifies the person's right to freedom of movement. And I think this is a value that actually becomes very important, especially in the context of the pandemic, because of all the movement control orders and isolation requirements. Article 19 then talks about the right to freedom of opinion and the freedom to choose and decide things for yourself, which is in keeping with autonomy, which is, again, an important value that we must consider. And lastly, in Article 25, it states the right of a person to health and medical care. And of course, this is what everyone actually seeks when looking for care at a healthcare facility. And this is really what we need to realize, that it is a right of every individual to receive the best healthcare that they can possibly receive. And so when we talk about incorporating or considering a patient's values in clinical decision, what we often try to ascertain in any situation is what are the goals of the care that we want to provide. And there are three key factors that determine these goals. That would be, first and foremost, comfort, which is a priority to everyone. But sometimes if you are looking at improving survival, you may have to actually trade off some of this. Survival, of course, is a primary factor. But in some patients who are very poorly, they're very elderly and frail, survival sometimes may not really be such an important factor. And function, of course, is also important, because apart from just surviving, people want to have the ability to still maintain a meaningful kind of life, to do the things that they want to do. And so when they lose that function, sometimes survival may not be, so important if it means losing a lot of function. So the goals of care, considering these three factors, would be very dependent on each individual's values in terms of their general beliefs and values, their religious values, family values, and also community values. So now, how has the COVID-19 pandemic actually impacted on clinical decision-making? And what I think it has caused, very obviously, is a lot of tension between those values of the individual person and the reality of what sometimes the healthcare system or has to provide or can provide. For example, the tension between the public health procedures like quarantine, isolation, contact tracing, and the movement control order, trying to contain the pandemic, and leading to that tension of restricting a person's right and freedom of individuals. Another cause of tension is where we are facing the resource limitations that we have because of the large numbers of patients with COVID-19. So leading to insufficient hospital beds, a need to triage for ICU admission, and limited medications. At the same time, we know that everyone has that right to life and health. And so this causes a lot of tension and conflicts that arise because of all this tension, whereby patients are forced to be in situations that they do not want to be in, like being admitted to an isolation ward because they're suspected to have COVID or they're tested positive, being quarantined for long periods of time, being forced to stay at home because of a movement control order, and sometimes having restrictions if you are not vaccinated yet. Other conflicts that also arise includes the fact that patients and families are sometimes not able to fulfill all their needs, such as their surgical and medical appointments being postponed. And in terms of resource limitations. Sometimes those who have severe illnesses, severe COVID-19, may actually get less than optimal care. And because of the isolation, patients are unable to be with their family and loved ones. And if they pass away, funeral and last rites are far from optimal. So a lot of these conflicts that have arisen, how do we deal with it? I think that, well, of course, nothing is very optimal right now. But I think one thing that is important is shared responsibility. The responsibility shared by the government, first to provide decisive leadership and coordinate ministries and sectors towards best interests of the patient and the people. Political interests to be put aside, and public health laws to be used with respect and fairness. The healthcare sector, on the other hand, has a responsibility to work as a team and to exhaust the highest level of medical and scientific expertise to ensure provision of care, and to listen to the needs of the people and advocate to our national leaders. The people, on the other hand, have a responsibility to maintain calm and observe health and safety regulations, to advocate for collective measures, honest information, and solidarity from everyone in dealing with the pandemic, and also to come forward for screening and management as required. Apart from that, trust and trustworthiness is very important in dealing with all these conflicts. And this is hopefully gained through transparency, with open communication always, ensuring the needs of vulnerable populations, particularly like elderly, migrants, disabled, and being inclusive rather than exclusive. Having accountability with clear lines of responsibility and ownership of care, and up-to-date evidence-based policies and procedures. And good governance, having ethical decision-making which involves all stakeholders, efficient and effective processes, and supportive policies for frontliners in order to provide the best care for the people. So having talked about all of these conflicts and tensions, I now just like to talk a little bit about one of the most difficult, most tense and challenging clinical decisions which we've had to face during this pandemic, and that is that of allocating things like ventilators and critical care, and also considering who may be admitted to an ICU and who may not benefit so much from the ICU. Essentially talking about triaging. But even in a situation like this, I'd like to highlight how patient values are still very important. So the 5 factors that we consider when we're triaging or considering crisis decision-making includes, first, estimating the person's survival. And this is dependent on the likelihood of their benefit from the interventions, the prognosis overall, considering their comorbidities, and also their life expectancy due to underlying conditions, and also depending on their age. Apart from that, though, apart from just the survival, we also need to consider the patient's values and wishes. And this is essential in that decision-making, to talk about their anticipated quality of life. And so we need to find out whether what we do for them is going to match up with their values and expectations, and what are their wishes. And so just to highlight, when we do triaging or crisis decision-making, the first step is actually application of an exclusion criteria. So we would look at who would obviously not benefit from ICU management. And this includes a host of conditions where they've got either irreversible conditions of brain pathology or disseminated malignancies or severe organ failures or congenital malformations. But another important point which highlights patient values is the group that explicitly, or those patients who explicitly express that they have a wish not to be intubated or ventilated or have aggressive medical interventions. So after we have applied that exclusion criteria, then we can actually consider a person's prognosis using survival estimation tools, looking at their short-term survival probability with things like SOFA scores, their long-term survival capacity, considering their chronic comorbidities like cancer or organ failures, and also their life cycle scales, considering their age and their potential future years of life. And so once we've applied these survival estimation tools and we prognosticated, we need to then use what we understand from these prognostication tools and then conduct a discussion with the patient if possible, but if not, with their family, and to check if the patient had previously expressed certain values and wishes about what they would want for themselves. We need then to explain the likely outcomes in terms of quality of life, and not only in terms of survival. So sometimes the patient may survive but have very poor quality of life. And so when we talk to them, we need to actually kind of explain things in a way that helps us to assess their values. So saying something like, even if she does survive, there is a possibility that she may become very disabled and may not be able to care for herself. Do you think she would be able to accept such a condition? So we're not saying whether we are going to do certain things or not, but we just want to see what their values are. And if they say no, they would rather actually die rather than to end up like this, then perhaps this would help us to understand what their values are, and it may help us with that decision making. So in conclusion, I'd just like to stop here just to highlight the fact that patient values are still always at the center of our decision making, and it is applicable even in the situation of a crisis, a pandemic, like what we're facing now. And it is something that we should always remember and apply whenever making our decisions for patients. Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to everyone. My name is Fadhlina Alias, and I'm currently teaching law at the Faculty of Sharia and Law, University Science Islam Malaysia. First and foremost, I would like to warmly thank the organizers of this e-symposium for kindly inviting me to participate. And I must add that I'm quite awestruck because many of the speakers and members of the audience today are people who I admire their work and have referred to in the course of my research, including Dr. Richard Lim himself. So I am deeply honored. Now, for the topic patient-based values in clinical decision-making, on my part, I will first be touching very briefly on the shared decision-making process in palliative care, and then I will proceed to provide an overview on the significance of religious considerations and religious perspectives on the withholding and withdrawal of life-sustaining treatment. And then for the major part of this presentation, I hope to offer some insight into the legal justifications of withholding and withdrawal of life-sustaining treatment, how the law perceives this particular end-of-life decision, and the position in Malaysia. Now, decisions in palliative care involve many ethical dilemmas, which require the need to balance between autonomy and guided paternalism. So the doctor not only provides the patient with the relevant medical information, but both doctor and patient engage in discussions on the medical and ethical aspects, including deliberation on the patient's concerns, values, and beliefs. So the decision is reached collectively through this partnership, and this provides a more conducive environment for mutual trust and understanding to take place. Autonomy is best described as a double-way street because it requires both patient and doctor responsibility. And this approach entails a positive synergy between ethical principles of beneficence and non-maleficence, because the balance in this approach is guided and motivated by what would be in the best interests of the patient and to prevent harm to the patient. Now, when we talk about a patient's best interests, this necessarily includes the patient's personal values and beliefs. And religious beliefs are especially significant at the end of life, where the patient more often than not experiences a more profound degree of physical distress and emotional upheaval. Now, religious beliefs and cultural values provide an indirect form of control. They help to alleviate the effects of stress, anxiety, and depression that may be experienced by those suffering from chronic pain, disability, or serious illness. And they also serve as the inherent ethical basis for clinical decision-making and effective care. The ignorance and lack of sensitivity in understanding and appreciating these religious and cultural attitudes towards death and the dying process constitute a barrier towards effective communication between doctor and patient and the provision of competent end-of-life care. So there is a need for doctors to recognize the way in which different religious and ethnic groups perceive the information relating to their prognosis and treatment, as well as the reasons underlying their responses, which frame their responses in relation to the decision-making process. In that regard, cultural competence is therefore essential and requires skilled verbal and non-verbal communication as a means of appreciating the differences between various value systems. Okay, this is just to show you the religious demography in Malaysia, and this is based on the 2010 census issued by the Department of Statistics Malaysia. The 2020 census has not been officially released yet. So we can see that the four major religions in Malaysia are Islam, followed by Buddhism, Christianity, and Hinduism. And Muslims make up over 60% of the entire population. Now, I'm showing you an overview of the four major religions in Malaysia, how they perceive the withholding or withdrawal of life-sustaining treatment. Across the board, we can see that there's a common agreement that it is permissible and it's based on more or less similar grounds, that the treatment is futile and it provides no benefit to the patient, and also if it is burdensome to the patient to continue receiving such treatment. For Islam, there is a third requirement that needs to be fulfilled, and that is there is a need to obtain the expert opinion of medical specialists. For the Islamic ruling on the withholding and withdrawal of life-sustaining treatment, this has actually been incorporated into contemporary guidelines, as you can see in the fatwa issued by Saudi. It states there that it is permissible for doctors to discontinue such treatment on the condition that two competent doctors have confirmed that it is futile and death is inevitable. And likewise, the ruling is also integrated in the Islamic Code of Medical and Health Ethics. Now, in Malaysia, we do have a similar fatwa that has been issued by Muzakarah Fatwa Kebangsaan, only that it is placed in the context of cases where patients are in a persistent vegetative state. In Malaysia, we don't have proper guidelines on the religious perspectives in palliative care, but I just like to quickly show you that in Australia, the Queensland Health Department has issued guidance in the form of booklets on religious perspectives with regard to the delivery of healthcare, including end-of-life decisions. And this has been done with the help and in consultation with the respective religious councils. Yeah. So Australia is one of the top 3 countries which have successfully fully integrated their palliative care into the mainstream healthcare system, and also has an inclusive regulatory framework on palliative care. Now, it gives me great pleasure to showcase this book. I believe many of you are familiar with it. This Handbook of Palliative Medicine in Malaysia is published under the auspices of the College of Physicians from the Academy of Medicine and the Malaysian Hospice Council. It's edited by Dr. Richard Lim himself and Dr. Diana Katiman. Now, this is a commendable initiative by local palliative experts, and under Section 2, it includes an overview of how death and the dying process are perceived according to the 4 major religious groups in Malaysia. So if there are plans to produce a second edition and expand its contents to include religious input on end-of-life decisions and the legal perspective, then I would very much welcome the opportunity to hopefully be able to contribute as well. Okay, so we've come to the final part of my presentation on the legal justifications on withholding and withdrawal of life-sustaining treatment. Before we talk about the position in Malaysia, it is important to first highlight the common law principles on that particular end-of-life decision. Malaysia, having been under British rule in the 19th and 20th centuries, inherits much of its legal system from the common law in England, as in the case of other Commonwealth countries such as India, Canada, and Australia. So prevailing common law principles are persuasive, and they constitute a significantly relevant source for Malaysian judges to refer to, especially in areas in which there is a lacuna in the law. In this case, there is indeed a lacuna when it comes to end-of-life decisions or issues relating to palliative care. The landmark case in England, which clearly laid down the common law principles on the withholding and withdrawal of life-sustaining treatment, is the case of Airedale, NHS Trust, and Bland. Now, this is a case that happened pursuant to one of the worst football disasters that occurred in Sheffield, England on 15 April 1989. It involved the semi-final match between Liverpool and Nottingham Forest. The match was an FA Cup match. So you can imagine the massive swarm of spectators flooding to Hillsborough Stadium. Now, the gentleman on the top right-hand corner, my right-hand corner of the slide is Anthony Bland himself, and this photo was taken a few hours before he walked to Hillsborough Stadium, and which ended in tragedy. So 95 people died immediately or shortly after being trapped in a human crash. So what happened was this was a misjudgment by the safety management team of Hillsborough Stadium. There was a devastating human crash, and Anthony Bland was one of the victims who suffered irreversible damage to his cerebral cortex, which rendered him to be in a persistent vegetative state. After 3.5 years being in that condition, his attending doctor applied for a court declaration to cease further treatment, and this case went all the way up to the highest court of appeal in England at that time, which was the House of Lords. So the House of Lords decided to grant the court declaration on the basis of a clinical assessment that stated there was absolutely no hope of recovery for Bland. He would no longer be able to have any semblance of quality of life, and thus any medical intervention would be futile and not in his best interests. Pursuant to this case, the court decided that it's interesting to note that in this case, the parents of Anthony Bland did not object to the doctor seeking a court declaration to cease further treatment. And so after this case, the House of Lords decided that if there is no objection from the family members towards the doctor's decision to withhold or withdraw life-sustaining treatment, then there is no need for the doctor to seek a further court declaration on the matter. These are the legal principles where the court laid down, the House of Lords laid down in the Bland case, and these legal principles clarified the position of withholding and withdrawal of life-sustaining treatment, in which the court held that it is to be considered as an omission or a failure to act. It is not unlawful because doctors are not under a duty to prolong life at all costs. If the treatment is futile, then the duty to provide medical care ceases. So there is no illegality in withholding and withdrawal of treatment. The doctor refrains from artificially prolonging life and allows death to take place naturally. And in the eyes of the law, the patient's death would be regarded as having been exclusively caused by the injury or disease from which the patient is suffering from. The judges in the Bland case also laid down the underlying principles with regards to the type of patients from which the withholding and withdrawal of treatment is to be done. So two categories of patients are differentiated: patients who are incompetent, unable to partake in the decision-making process, and those who are able to do so. In terms of patients who are incompetent, such as in the case of poor Anthony Bland, the principle of best interests would need to be applied. And this would encompass a broader ethical, social, moral, and welfare considerations, which also include the patient's wishes and values. So patient's wishes and values are an integral component in the decision-making process when considering to withhold or withdraw treatment from patients who are incompetent. In the case of those who are able to decide for themselves, the patient's autonomy would be the underlying principle. If the patient refuses to continue with such treatment, then the doctor must respect those wishes. So the patient's autonomy in itself provides a defense for doctors from any criminal liability. Now, if the doctor, on the other hand, proceeds to administer treatment against the patient's request, then that may amount to trespass to person, and the doctor may be liable for assault and battery. Now, what about the position in Malaysia? Currently, there is no specific legislation in Malaysia dealing with the withholding and withdrawal of life-sustaining treatment. But nevertheless, the legality of this end-of-life decision can be examined through the existing statutory provisions in the Penal Code, which is the country's main piece of legislation governing criminal offences. To date, there are no local judicial decisions on the matter, as issues pertaining to palliative care are treated as purely medical decisions and have yet to be brought before the Malaysian courts. Now, I'm afraid I'm running out of time, and I do not have the luxury of going into the technicalities of the provisions of the Penal Code. Let me just try to summarize it as best as I can. In terms of the position of withholding and withdrawal of life-sustaining treatment under the Penal Code, we can draw the inference on its legality from two relevant sections, Section 32 and Section 43. Now, the more important section is Section 43 because that section defines what is to be considered as an illegal omission. In order for an omission to be considered illegal or unlawful, it needs to fulfill either one of three requirements. Number one, if it is specifically stated to be an offence under the Penal Code, then that omission would be illegal. And in the case of withholding and withdrawal of life-sustaining treatment, there is no such provision in the Penal Code which prescribes it. So it does not fulfill the first requirement. The second requirement, an illegal omission must be that which is prohibited by any other law apart from the Penal Code. And we can safely answer this in the negative for in the case of withholding and withdrawal of life-sustaining treatment. Now, the third requirement is that illegal omission a ground for civil action? And what this means in the context of palliative care or delivery of healthcare for that matter, if a doctor is under a legal duty to act, then the failure to perform such an act will amount to an offence. So the question that needs to be answered is a doctor under a legal duty to continue providing treatment that no longer benefits the patient? Okay. In referring to the common law principle in Bland, which we discussed just now, it is established that when the treatment no longer benefits the patient, when it is futile, the doctor ceases to be duty bound, and the doctor, because the doctor is not ethically and legally obliged to provide futile treatment. So this provides credence to the submission that it is unlikely that the withholding or withdrawal of life-sustaining treatment would amount to an offence punishable under Malaysian law because it does not, in the first instance, fulfill any of the requirements of an illegal omission. However, it must be noted that the doctor still owes a duty towards ensuring that the patient is accorded comfort and care till the very end. I'd also like to talk about the application of distributive justice in resource allocation, because as we all know, not too long ago, we had the crisis where there weren't enough supply of ventilators to be given to COVID-19 patients who required ventilatory support. And doctors had to make that difficult decision in choosing between patients who would receive vent. Okay, so in terms of the principle of justice in the distribution of resources, it necessitates equity, not equality, but equity to be exercised in the allocation of healthcare resources and services. And the rationing for patients at the end of life, or what we refer to as micro allocation, warrants a just balance to be drawn between three considerations. Number one is very much related to medical fertility, where you assess the treatment's likelihood of success and you distribute the resources to patients who can reasonably benefit from it. And this needs to be weighed with medical utility, in which the consideration is whether by providing the patient those resources, it would maximize the patient's welfare and needs, and also the need to avoid inappropriate use of resources so that those resources can be used to treat and save more people. Now, before I end, I would like to showcase to you some excerpts from the statutes enacted in Australia that cover palliative care. And this is what I said before, that in countries such as Australia, the UK, and the US, which have fully integrated palliative care into their mainstream healthcare system, they also have a comprehensive regulatory framework to protect doctors who are practicing in the field. For example, if we look at Section 282A of the Queensland Criminal Code 1899, subsection 1 states that a person is not criminally responsible for providing palliative care to another person if it is done in good faith, with reasonable care and skill, with regard to the person's state at the time and all the circumstances of the case. There is a subsection which provides the definition of what is meant by good medical practice and palliative care. Let me just draw your attention to paragraph B of subsection 5, because I think this is quite this is a provision that gives ethical standards, that legal affirmation. It's backed by legislation, so the ethical standards in Queensland are considered to be legal standards because it's incorporated into Section 282A of the Criminal Code. It says that the recognised ethical standards of the medical profession in Australia also form what is known to be good medical practice. And if we look at South Australia's Consent to Treatment and Palliative Care Act 1995 under Section 17, which covers or governs the care of people who are dying. Now, subsection 1 is similar to Section 282A of the Queensland Criminal Code, but I'd like to highlight subsection 2 because I think this is a section, a provision, a legal provision that really clarifies the standing of a doctor who withholds or withdraws life-sustaining treatment. It states that a medical practitioner responsible for the treatment or care of a patient in the terminal phase of a terminal illness is under no duty to use or to continue to use life-sustaining measures in treating the patient if the effect of doing so would be merely to prolong life without any prospect of recovery or in a persistent vegetative state. And if we go down and look at subsection 3, paragraph B further emphasizes the protection to doctors in this respect. It says that the withholding or withdrawal of life-sustaining measures in accordance with subsection 2 does not constitute an intervening cause of death. So that's the protection given to doctors practicing palliative medicine in Australia. They have that legal affirmation that their conduct would not expose them to any criminal prosecution. Now, this is, of course, if the withholding and withdrawal of life-sustaining treatment is done in good faith, without negligence, and in accordance with proper professional standards. So I've come to the end of my presentation. I would just like to leave you with these two quotations, which I find myself, I humbly find that it encapsulates the essence of palliative care. Do as much as possible for the patient and as little as possible to the patient. And there is an end to cure, but there is no end to care. With that, I sincerely apologize for going 8 minutes over the time allocated to me. It's truly a struggle to explain legal justifications within the time frame given to me, but I hope it has been beneficial to all of you. Thank you very much for your kind attention.